Welcome to DroneLaw.Pro, where we break it down for you, everything sUAS. Today we're going to be talking about SkyPan International's response to the FAA enforcement letter, the civil penalty letter sent last month with a proposed $1.9 million fine. So just to recap, the FAA did an investigation and they found that between 2012 and 2014, there were over 40 flights that the FAA believed were in violation of the Federal Aviation Regulations. The investigation took a long time, but eventually spit out a number of findings. Because SkyPan did not have a Section 333 exemption, it had to comply with all the Federal Aviation Regulations, many of which really can't be complied with a sUAS, and then spit out some findings which really amount to careless or reckless operation within the NAS, within the national airspace. In our prior shows, we kind of broke down the civil penalty letter issued by the FAA. Today, we're going to do something a little different. We're going to take a look at SkyPan's response to the FAA, which was made public this weekend. And we're going to take a look at the subpoena that the FAA issued in order to conduct its investigation against SkyPan. So SkyPan on its website posted a response to the FAA, and it lists out a number of items which it is putting in play as part of its response. We'll take a look at each one. You'll see that the very first one is essentially that SkyPan is good for business. Now, that's not much of a legal offense, but they're making the policy argument. Keep in mind, under Section 333, in order to get an exemption, the FAA has to find good cause that the operation enabled by the exemption is in the public interest. So they're essentially saying here that, hey, we're safe and we're a good company, so we shouldn't be penalized. It's a policy argument. So beyond the policy arguments, they talk at length about their long history of providing great photography for leading customers, and they talk about their time-tested safety protocols and procedures, their technology and their flight systems, and the fact that they work for leading companies. Essentially, this is a customer loves us type argument, which isn't going to get anywhere with the FAA, but makes for really good public relations when you're doing damage control in a situation like this, because I'm sure their customers are pushing back on what happened here. So look at SkyPan's putting out some press release type items that are for public relations, and our goal is to take a look and find out what they're really doing here on the legal side to get some insights. And this is where it gets interesting under C. They start making legal arguments that they're operating in what they call privately owned airspace, which is an interesting argument. They're saying they're above private property and therefore they are flying safe, that they're not in the navigable airspace that is regulated by the FAA, and if they're not in navigable airspace, then the FAA has no jurisdiction. And then they talk about the airworthiness of their aircraft, which wouldn't really matter, I guess, if they weren't in navigable airspace, which was within the reach of the FAA. So let's talk a little bit about how we got here. The FAA started an investigation against SkyPan back in 2012. They ultimately issued subpoenas. So as a Section 333 customer, you should be aware of how this could work if you get pulled in on an investigation. They initially issued subpoenas to SkyPan itself, asking for, of course, any information. But then they started to target SkyPan's customers like Maclo Properties in New York. So while SkyPan objected to providing information, Maclo, the customer, of course, spoke to the FAA and identified documents and emails and invoices and all the types of records that eventually came back to haunt SkyPan. Because even if SkyPan had been able to fight some of this information, your customers, your Section 333 customers, are also going to be the target of an investigation. These things are typically pretty visible. So you'll see some declarations here by some FAA attorneys and administrators which kind of detail the history. There was a preliminary investigation based on an anonymous tip, and they issued subpoenas to get emails and all communications relating to SkyPan's activities, commercial drone activities or helicopter activities. They sent letters back to the FAA, SkyPan did, saying that they wouldn't comply with the subpoenas. Skypan eventually was a subject of another complaint by a third party. We don't know who that party was, complaining about the flights Skypan was making. And in February 2012, another anonymous complaint was issued against Skypan. Big risk for you folks is your competitors coming out. And then based on these complaints, they started talking to Skypan's customers. And Mr. Dubrow from MacLeod Properties, one of the customers, started providing information to the FAA indicating that flights were occurring up to 1400 AGL with unmanned aerial systems, allegedly. So we start to see how this case was put together and how this investigation started to evolve. We have more declarations by the safety inspector of the FAA, and it talks a little bit about opening the investigation in 2012. And here's the interesting thing. After they find out there was a problem, the FAA sent letters to Skypan, the purpose of which was to educate them, not to bring enforcement. So they provided them all the regs and these types of things. And apparently, Mr. Siegel allegedly agreed with the FAA that Skypan would cease using UAS or sUAS for these commercial activities. So this is March, April 2012. And so ultimately, based on some more anonymous phone calls to the FAA, Mr. Dubrow, the customer from MacLeod Properties, started telling the FAA about these flights, which occurred after Skypan apparently had agreed to cease and desist. So let's talk a little bit about the Perker case, which is where really some of the initial fight with the FAA over their authority began. And essentially the FAA brought a $10,000 fine against Rafael Perker, alleging that he was engaging in reckless flights within the NAS. And the fundamental issue in that case was whether or not, at least from the NTSB standpoint, whether or not a drone was an aircraft under the FAA rules. The court eventually determined that the definition of an aircraft would be the controlling issue in the case, and they took a look at the CFRs and determined that an aircraft is any device used for flight in the air. And their conclusion essentially was that a drone or sUAS was an aircraft, manned or unmanned. So when we get to this concept of private airspace and the argument that we now see Skypan making, this appears to be a new attack on the FAA's authority to regulate drones. If you're flying above airspace that's not navigable airspace, then theoretically the FAA wouldn't be able to fine you. So what is navigable airspace? Under Title 14, Part 1.1, under general definitions, it's any airspace at or above the minimum flight altitudes prescribed under the rules, which are about 1,000 feet in many instances, including airspace needed for safe takeoff and landing. And so it is at or above minimum flight altitudes. Let's say in our argument it's 1,000 feet, including airspace needed for safe takeoff and landing, which could be anything on a flight path towards an aircraft, towards an airport facility. So what we're seeing here is the beginning of a legal argument that we can anticipate that we are going to start seeing from Skypan about whether or not the FAA has any authority. Now we get back into some more fluffy, non-legal type arguments that Skypan makes on their website. They say, hey, look we started working with the FAA a long time ago about getting permission, that they belong to a number of trade associations and that they respect the safe flight rules. That they're a market leader in RC helicopter photography in the country with really high-end clients that have done $55 billion in real estate development, and that they want to comply with the safe flight parameters that the industries put out. So these aren't going to be necessarily legal arguments; they're equities arguments. So if you have a Section 333 exemption, then you want to comply. If you don't have a Section 333, then you need to be aware of how a regulatory action might proceed against you and how the FAA goes about conducting an investigation for unsafe flight. That'll do it for this episode of Drone Law Pro. We will see you next time. Until then, fly safe.